if so much as one side doesn't consent in writing, that's it. You've got no jurisdiction.
But the Act, as we know, does not define it.
Building owner knew about it, was getting the award.
Well, you know, you've got no notice, no act, and I think no dispute, no award.
Security should be given by an adjoining owner where the building owner is calling upon them.
And that's an interesting one, but we won't go.
I had no idea that this was happening.
I thought I'd just set the scene.
It specifically attaches the Act,
Yes.
2 words to dispute. She was not aware of it at all. That's the first at which she found out that there was any damage.
Just at that stage, because they don't, until they do the excavations, they're not familiar with ground conditions and everything else. So there will be another award.
Pretty confident is why that provision is in the Act.
Hi, I'm Grace, and it's lovely to be here hosting alongside Ben Mackie from the Party Wall Collective. Today we have our special guest Stephen Cornish, who is joining us to talk about the jurisdiction of a party wall surveyor under the Party Wall Etc. Act 1996. Stephen is a well-known and respected chartered surveyor based in London. He has an insatiable passion for architecture and its history. He lectures on party wall matters and is widely consulted as a third surveyor, settling party wall disputes between party wall surveyors. I'll mind out of the way and let retired Judge Edward Bailey take my space for the rest of this conversation, who you'll likely have seen on our previous podcast. So today we'll be speaking about various matters. So I'd like to kick off. What is a dispute? Ben, over to you.
I think that's a great question. It's a question that actually, before coming onto this podcast, you put it to me, and I thought, actually, that's such a simple question. But then the more I thought about it, I thought, this is a great question. What is a dispute? It should be really easy, shouldn't it?
It should be.
And yet, you know, I feel like there's quite a lot of cases that come out because surveyors don't seem to understand what a dispute is. And, you know, it almost makes me think, do I fully understand what a dispute is? But primarily, I think it's born out of there has to have been a notice, and a dispute has to relate specifically to that notice. I think that's the scope of a dispute, you know, broadly speaking. But what's your views on?
Yeah, I would agree, Ben, and certainly that's a starting point. And in many ways, the first phase of this, what is a dispute process, is fairly straightforward. Although we haven't defined what a dispute may be, we're pretty sure as surveyors what it is once the notices has been served. And we'll come on to it later, but there's the second phase, the further dispute. And this is where recent case law has sort of unearthed the thing that we have been struggling with. You know, we've assumed, we've been arrogant enough to think we know what a dispute is. And clearly the courts have said, well, you didn't, Mr. and Mrs. Surveyor, did you? But, you know, I am in the process, a bit of self-promotion here, but I am in the process of writing an article about what is a dispute. And I looked to Selby versus Whitbread because this is what initially my hero, Judge McCarthy, tried to tackle, but he didn't in a way. He recognised it was through the civilised conversation between the two surveyors that he determined that there was a dispute. And he didn't attempt to define one because he felt it would be setting it in too much of a rigid way, too much of a rigid framework. But that said, I didn't leave it at that. And the most recent court case we've had where I believe there's been an attempt to define a dispute was in Lyonholme Sussex Limited versus Brighton Hove County Council. And it was the appellant's barrister there that had a stab at it and tried to direct the judge towards it. And he quoted from Lord Denning, who and McCarthy was considered to be an early version of Denning, quite controversial. But Lord Denning, admittedly, quoting in terms of a construction arbitration, said that there must be both a claim and a rejection of it in order to constitute a dispute or difference. There must be a claim and there must be a rejection. And that same appellant's barrister then directed the judge to another case, Fast Track Contractors Limited versus Morrison Construction back in 2000, where Judge Thornton said a dispute can only arise once the subject matter of the claim issue or the matter that has been brought to the attention of the opposing parties. It must have been brought, the claim must have been brought to the attention of the opposing parties, and the other side, or the opposing side, as the judge referred to it, must have time to reflect on it and maybe agree or disagree. So there's some guidance, but the Act, as we know, does not define it. But that's as close as to it. I think Denning has come probably as close. There must be a proposal and there must be a rejection. And that leads us part of the way. There's two things to consider. There's actual disputes and deemed disputes, and the latter is more problematic.
Oh, definitely. I mean, I completely agree with what you're saying as well, that claim and rejection is required. And we have Edward Bailey with us, actually, who's sitting on the side, who may be able to give us information on legal cases better than I can articulate as a surveyor. But what we have is Evans versus Patterson, which was 2021, where essentially there was a claim for damage that the surveyor served an award on the building owner, and she was not aware of it at all. That's the first point at which she found out that there was any damage. So she never had that chance to accept or reject. And for me, again, there cannot have been a dispute. And is that correct, Edward, in terms of the thrust of the case?
So that's correct. This was a case where the adjoining owner had suffered damage to his building during the course of the building owner's works. And for various reasons, it took the surveyors a very long time to get round to looking at the damage and quantifying it. They met, decided on a figure which the building owner should pay the adjoining owner for the damage caused, and produced an award. And the first the building owner knew about it was getting the award. They'd completely forgotten to tell her that there was this claim and the amount of money that was going to be awarded. There couldn't be a dispute, she says, because I had no idea that this was happening. And the judge, that was Judge Backhouse, agreed and said no dispute, and therefore there could not have been a proper award.
Oh, you got no notice, no act, and I think no dispute, no award. Really?
Exactly.
Literally. Have I just...
That's right, that's absolutely.
I think, but it's still, I feel in many ways, Ben, it still only partly answers your question, because as I said, I've already intimated we've got actual dispute and deemed dispute, haven't we? And I made some quick notes here, where the Act specifically talks about, refers to a dispute. We've got it, obviously it must be between the building owner and the adjoining owner, but any dispute, for example, where it's specifically the word dispute is used is 22A, raising a flue, similar dispute, demolishing and a party structure and rebuilding it. The fourth one, any dispute as to plans and sections under 7.5b. Any dispute as to what deviation there should be from the agreed award plan sections 7.5 again. Any dispute as to the responsibility for expenses under 11.2. Any dispute as to the expenses of making good damage caused by the building owner carrying out repair work, not development, repair work under 11.8. Any dispute as to what security of expenses should be given to the building owner under 12.1. And the final point I've got there, any dispute as to what security should be given by an adjoining owner where the building owner is calling upon them.
That's an interesting one, but we won't go there.
That's for another. But the point I'm trying to make is that happy days, the Act tells us where there's dispute there, although it's not defined. But the problematic one, and these cases tend to flow from it, is what was a deemed dispute? Was there a response from anyone? Was there supposition made? But the Act again has 4 instances where deemed dispute will be adjoining owners not served consent notice under Section 5 for a Section 3 notice. The counter notice, that's another deemed dispute area which is referred to as such in the Act. A consent notice not served in accordance with 6.7 following 6.5, and the fourth one, account served for expenses payable by the adjoining owner, and he subsequently objects to it under 13.2. So some degree, again, we got some guidance as to what is a deemed dispute there. But it is these further disputes, Evans versus Patterson 2021 and KR Group's Adeco 2021, where Judge Parfitt dealt with all these various awards served by the surveyor on different adjoining owners who were aware of the situation. And so what if there is silence on a further dispute? what somebody considers further dispute.
I would say we've got another question which will be under section 10.4. What steps should the surveyors take to settle a deemed dispute? So we'll save it for that, because I completely agree that that is like a good path to go down in terms of, I think we can talk about what a deemed dispute is now, but then moving forward we'll talk about perhaps the actions that a surveyor can reasonably take to settle that deemed dispute. So it's slightly sort of different.
Do forgive me for the sort of amount of time I spent on that, but I thought that set the foundation, because the other questions flow from it. There won't be so much verbiage from me, but I thought I'd just set the scene.
It specifically attaches the Act two words to dispute, you know, like in terms of a dispute arising or like a deemed dispute, or you have what we call an actual dispute, which is defined as a particular problem that a surveyor has that will then deal with, you know, the surveyors will be expected to adjudicate on that. A deemed dispute, I think, really involves a surveyor almost finding a dispute, and some people would say that that's dispute creation, in my opinion. I've got a little shake of the head from Edward, so
I think, may I suggest that what the Act is dealing with deemed disputes is the adjoining owner who, having received a notice, does absolutely nothing about it. And the Act is tailored to speedy resolution. And if you have an adjoining owner who's just been difficult, and the Act doesn't say at what point the adjoining owner is to be treated as having rejected the notice, then you leave it to the courts to decide when it is that the adjoining owner should have either agreed or dissented from the notice. It's much better for the Act to say, if you don't get an acceptance in writing within 14 days, then the whole notice is deemed to be in dispute. The difficulty, of course, is that while that makes a great deal of sense to stop the annoying adjoining owner who wants to bury his or her head in the sand, you end up with a situation where the whole of the notice is theoretically in dispute. And many notices, particularly party structure notices, will involve a whole range of works relying on a whole series of rights that the building owner has, detailed plans and specifications, and annoyingly, if the whole of that notice is in dispute, then there are a whole range of possible disputes. That could have effect later when you're talking about further disputes. But that's the point I'm making, which I'm pretty confident is why that provision is in the Act.
I've sitting there listening to that explanation. So when we've got a deemed dispute where it is the building owner that's now in a further dispute, is no longer responding, the adjoining owner said, well, you've caused damage to my property. You know, I want to invoke the provisions of the Act for either making a payment in lieu or compensation under 7.2. You're not responding, Mr. Building Owner. Deemed disputes on the other.
Yeah, I mean, the Act doesn't help there, does it?
I think the Act does help, potentially. We saw it misused with Kyson versus Shah, right? But it's not too, like, as long as the notice has been served, an adjoining owner that suffered damage could very well serve a 10-day request on the building owner with a view to actually now making that progress. So the adjoining owner has some privileges. It's not a great privilege to have damage, but you know, there's that 10-day timing which will start to pick up the dispute resolution process.
It is a peculiarity, isn't it, that the Act, as I said, is one of those 4 deemed disputes the Act is quite clear on, talks about payment in lieu, dispute over payment in lieu, where it was repair work only. But it just strikes me as odd that we have to consider in the context that the building owner is no longer responding. So, to get on to your question, to what extent can surveyors deal with damage caused by the building owner's works? Well, first of all, there must be a dispute. Are we in a deemed dispute situation? I put this to my audience when I was doing delivering the Selby versus Whitbread for the P&T, and people felt, well, that is a deemed dispute. The building owner is not responding. That was a general consensus, and it must be a dispute clearly and obviously caused by works in pursuance of the Act. And that is often the difficult thing, because we're often called in to say there's been damage, and we suddenly realise it was nothing to do with the notifiable and all the awarded works. So again, it's due diligence on the part of the surveyors to actually pursue that. That's very important.
It's also important, again, going back to that claim and rejection that we've seen,
Yes.
where I think the adjoining owner does need to probably make a claim in writing. I say probably, I would say that they will have to make a claim in writing, and that, you know, essentially there does have to be that rejection. But again, we've got that. I think what they need to do, the adjoining owner, taking advice from a surveyor, would be to serve that 10-day request, so that, you know, you do have that trigger point to have that dispute resolved, because, you know, it works both ways, doesn't it, the notice periods? So it will be to the advantage of the adjoining owner to invoke the Act in that way, or not invoke it, but as in, you know, to utilise it.
Yeah, yeah, that's quite right. And they must be given the opportunity to come to an agreement. And it's still those two parameters. There must be a proposal, there must be a rejection, mustn't there? But the lack of a rejection, Edward, is the deemed dispute area, isn't it?
Well, it's the failure to agree or disagree, which the Act has to deal with.
Yes.
Because otherwise, the person who's being asked to agree something could just put an interminable hold up on what the person asking for something will get. I haven't come out quite as I'd like it to be, but I'm sure you appreciate somebody is asking for compensation. They should get a response within a reasonable time. The Act does not, unfortunately, cover that particular situation in the same way as it covers the original notice. However, given that the Act gives you 14 days to respond to a notice, it would seem unlikely that a judge would come to the view that the receiver of a claim for compensation could delay matters for more than 14 days once they've received a request for payment.
Good.
Shall we summarise what a dispute is and move on to next question?
Yeah, I think we can, because obviously there's been, you know, I did deliberately talk at length about it, but I would say the basic principles: there must be a proposal followed by a rejection. I think that's it. Simply, it puts it, paraphrasing Lord Denning, I think, and you can't go much better than that. Really.
I completely agree with that. Just obviously it's within the parameters of the Party Rule Act. It all has to be traced back to a notice, but other than that, I agree, claim and rejection. To what extent can surveyors deal with damage caused by building work? For me, I would say that I've had sort of varying experiences with damage, and I believe that the damage has to be traceable back to the notice. I mean, everything goes back to the notice. I had a third surveyor award once where a hanging tile fell off the rear wall of a loft and allegedly damaged a neighbour's roof. And the third surveyor said, and he used the word mockery of the Act, if surveyors and the Party Rule Act couldn't deal with this damage. My argument was simply, look, we can deal with it, it's not a problem. On the side, not as a party wall matter, not in an official award, because a hanging tile has come off a rear wall. What part of the Act can you relate that to? So, you know, to what extent can surveyors deal with damage? I would say the very first thing a surveyor should be doing is, have I got the jurisdiction? I mean, again, this is what this podcast is about, really, the extent of the jurisdiction of a party rule surveyor. Am I legally entitled? Am I allowed to deal with this damage? And if you can't trace it back to notifiable work, you cannot deal with that damage. So that's the first sort of parameter that I set.
Yeah, I always take the view, and when I'm training my team at Woodwards, you know, I always say that if you have to stand in front of Edward Bailey, and if you can't convince him that you're correct, how on earth are you going to take things forward? You've always got to imagine you've got to be there in front of a judge explaining how you came to your decision. And you're quite right, Ben, you know, it's got to be traceable. Is there a probability, once you've looked at all the evidence, you know, was there works being undertaken in, under Section 2.2, where the drilling, the vibration dislodged it? And you could, I know some surveyors go further than others in terms of a speaking award, you know, rather than just say, this is my decision. And I know Edward sort of raises his eyebrows at me sometimes, but I do sort of probably go a little bit too far over the top, I suppose, of giving an explanation. But I take the view, I don't have a problem with any of my awards being appealed, but I like to think I'm helping the judge. And he was saying, well, I can see what Mr. Cornish is saying here, but he's completely wrong. But at least it narrows it down. So yes, you look to see what is the probability that those notified and awarded works were the source of that damage. and you've got to be able to convince yourself before you then convince Edward Bailey about it. But we know, don't we, that there's 11.8 says that where building owner is required to make good damage under the Act, the adjoining owner has a right to require that the expenses of such making good be determined in accordance with Section 10. So there's our jurisdiction. Yep. There's our jurisdiction, and pay to him in lieu of carrying out the work to make good the damage. And we know that payment in lieu and making good is only pertinent to Section 2, certain Section 2 works. We've seen it, haven't we, introduced in an award where there's just excavations, which is ultra vires. I think it was the Derbyshire case where the judge picked up on that, said that you shouldn't be including payment in lieu and making good where there's only Section 6 works taking place. And we know that leads on to the next part of the jurisdiction, 7.2, isn't it? That unless, and that would probably more often not, I mean, it's on face value, it's a wide-ranging compensation provision in the Act, but it still requires some homing in on was it to do with the notifiable works. And Section 7.2 is, again, there is a possibility that if the parties cannot reach an agreement, they can approach the surveyors to actually make a determination under Section 10.
No, I think that's quite right. There's something else, that I would add, going right back to the start, that is really important, especially with the recent case of Shah versus Kyson. Yeah. Was there a notice that was served? I mean, going back right to the basics, because was the Act invoked? Can I actually deal with this as a surveyor? So I always tend to go back to notices just all the time to make sure that there's jurisdiction. So whether it's tracing damage to a particular notice or understanding that there was no notice that has, nothing's been served, so therefore we've got no jurisdiction. I do believe that surveyors can deal with damage if there was no notice served on the basis of consent in writing from both parties, that they will follow the party wall procedures. I think that's the only thing you can do. Aside from that, if so much as one side doesn't consent in writing, that's it. You've got no jurisdiction.
Absolutely.
So I think that's quite an important one to go back to.
Because we all spent a lot of time pre-Shah Kyson, the late Stuart Frame, bless him, and Graham North, Nick Isaac, myself, gave various presentations on retrospective awards. And the Kyson-Shah case hasn't changed our conclusions reached in those talks. It was all to do with the parties agreeing to invoke the Act retrospectively under contract, effectively. Like the Marylebone case was Adams versus Marylebone, one of the first cases, that Edwardian case, where they're talking, well, they don't use the phrase retrospective, but the parties agreed under contract to do exactly what you said, Ben, and that's to invoke the Act retrospectively. So there's nothing wrong with that. It's just obviously got to be clearly spelled out. And I've had situations where I've been the third surveyor and such a situation has developed. And I said, well, the letters of appointment are just your standard letters. They should be bespoke to recognise this situation. Go back and start again. Go back to your point. Ask them what they are asking you to determine. And it's pretty important. It's that due diligence again, isn't it? The starting point, which is the point you're alluding to. If it's not a notice, but they're agreeing outside the Act, they've got to be absolutely clear, so the surveyors can't be criticised as to what they're being asked to resolve. I get it as a third surveyor. I spend a great deal of time when I'm receiving submissions, looking through these, inviting responses and final rights of reply, and then before I actually embark on my award, I say, this is why I understand the dispute is. And we go through this process and they say, oh, that's not it at all. So we start again. But I actually get them to say, this is what I agree to my understanding of the dispute. And it's the same in the context of appointed surveyors.
One thing I would say is, I might have got the wrong end of the sticks. We've had a couple of conversations prior to this.
I could come in. If I understand you both correctly, you're saying that if the building owner has caused damage to the adjoining owner's property, and the adjoining owner wants compensation from the building owner, the adjoining owner can't simply proceed under the Act, can only do so if both he and the building owner agree to go under the Act. This is, may well be the right answer. It's a disappointing answer.
Is this in the context of no notices?
Well, No, we've moved on from
Yes.
notices, and I thought that's where you were getting. Building owner serves notice,
Yes.
proper notice, Section 3, party structure notice, these are the works I'm going to do. And an award is made. Two party wall surveyors say, these are the works you can do and this is the way you have to do it. The works are done in the appropriate manner, but there's still damage to the adjoining owner's property. Adjoining owner says, look at 7.2, you've got to pay me for it. Can the building owner say, okay, you've got to sue me? Or can the adjoining owner say, no, I don't want to go through the courts and judges and expensive lawyers and so on. I want our party wall surveyors to make an award. Now the building owner can say, well, where does it say in 7.2 that the party wall surveyors can make an award? Can one look at Section 10 and say, this is a dispute because you want £20,000 worth of compensation and I don't think you should get more than 2? Or does one say, well, the dispute that is dealt with in Section 10.1 is a dispute which is specifically stated to be a dispute in earlier sections of the Act? One of the problems that I see, which you have highlighted, Stephen, is the provision in Section 11.8, because in Section 11.8, where the building owner is required to make good damage under the Act, the adjoining owner has a right to require that the expenses making good be determined in accordance with Section 10. So that is clear reference to Section 10. And therefore, as I see it, a 7.2 dispute can be brought under Section 10. But there could be other disputes, for example, security for expenses. I hope I remember that correctly. There's security for expenses, Section 12, again says there can be dealt with the dispute. But there are other provisions where the Act gives rise to rights, but there is no reference to resolution of a dispute under Section 10. And for example, Section 11.11, where use is subsequently made by adjoining owner work carried out by the building owner, adjoining owner shall pay a due proportion, and for this purpose he shall be taken to have incurred expenses. It doesn't actually say, and if there's a dispute, it can be dealt with under Section 10. So the problem is the Act does not say in terms, and it would be much better if it did, the fact that if there is any dispute between adjoining owner and building owner in relation to any of the provisions of this Act, it shall be determined under Section 10.
What we're really saying there is that there might not be a continuity of appointment, i.e. that once we've served an award, our job is done. Is that correct?
Well, that's a sort of ancillary point, which I have to say the late Stuart Frame was very, very keen on, that as soon as you have a dispute and it is dealt with, then any further dispute is something where you have to go back through Section 10 and appoint or reappoint surveyors. So take the simple example, works are done, both parties appoint surveyors, in the course of the work damage is done, then there's a dispute as to how much the damage should be. It is up to either owner to say, well, although I had Mr. Smith last time as my owner, he's not automatically appointed. I want Mr. Jones this time. One of the difficulties is that a lot of party wall surveyors enjoy putting into their awards provision that if there are any further disputes, it shall be dealt with by the same surveyors. Now, the late Stuart Frame would say, well, you can't do that, and that is ultra vires. You can't come back and say Section 10, subsection 16 says this can't be challenged anywhere, because that doesn't cover situations where surveyors have acted in excess of their powers.
I think that there might be some crossover as well of the fourth question, which is, can surveyors legally award final or further inspections with payment up front? That's a bit of a side thing, but you know, the same sort of idea in terms of
It is,
jurisdiction.
yeah.
I think the way you've structured these questions is great. The sequence is really good, Ben, because what I was going to say to Edward there, over the years I've looked at two sources here. Nick Isaac, who feels that 7.2 can be engaged if it's damage caused by the works of that specific notice. If notices, a subsequent notice has been served, they've suddenly realised they've left something out, it doesn't necessarily mean that the same tribunal would be in place. That's what he said. But I also looked at Stephen Bickford-Smith many years ago, and I know you were a student of it. When the first time we met, you'd read this book, hadn't you? And it was going back to Selby versus Whitbread again. And this is, I'm old enough to have worked under the old Act, 1939, where Section 55 gave surveyors ongoing jurisdiction. And that flowed from the 1894 Act that Mackie was using, where it was quite specific. And it was, they had the right, the jurisdiction surveyors, to continue to make awards during the process of the works. So what does Stephen Bickford-Smith et al. Say? They say Section 1010, which is new in this Act, has dropped the reference to settling matters in dispute from time to time during the continuance of the work. It was partly this phrase which enabled Judge Mackie in Whitbread to describe the jurisdiction of the surveyors as follows, and we don't need to repeat Section 91, but the conclusion of Stephen Bickford-Smith is, and Andrew Smith, it was not thought, however, that the removal of that key reference, ongoing jurisdiction, from previous legislation, it was not thought, however, the removal of the key reference that settling matters from time to time has deprived the surveyors of their power to make successive awards as separate issues arise.
Well, that's right for judicial determination, isn't it? Because if you have an act which contains those words, and then you have a subsequent act which it can be argued expressly omits those words, then is not the proper argument the intention of Parliament was not to allow surveyors to have a continuing jurisdiction?
And I was caught out when I gave this Selby versus Whitbread, not caught out as such, but it was a question I hadn't really considered. Somebody said, well, yes, we do a lot with residential disputes, but commercial projects, where there's enabling works have to be undertaken, so there will be an award for enabling works, which are still notifiable excavations, but the main design cannot be formalised at that stage because they don't, until they do the excavations, they're not familiar with ground conditions and everything else. So there will be another award. Success, and this is the point, I think, in that context that Stephen Bickford-Smith and Andrew Smith are talking about. So that they're talking about, I probably did them injustice, I didn't quote it fully though, it says that this power of surveyors having continued jurisdiction is not only useful, it is essential a feature of the procedure under the Act. And that was an example that was thrown towards me, and I thought, yeah, well, I can see that.
I mean, I would go back to something fairly basic, which is just that appointments cannot be rescinded. So for me, that there may be a level of, you know, what does that mean? If it can't be rescinded, does that mean that you're kind of stuck with the surveyor?
Well, you have to ask what the appointment is for,
yes.
And that appointment can't be rescinded. But then if it goes on, I mean, of course, it makes eminent sense that the two surveyors who've made the original award should make awards covering any matters arising out of the same works that they have originally awarded. And it could be open to a judge, and I'm speaking to Ben here, who's a great fan of Amir Sadiq and Kowalik. But it's open to a judge to say, well, you've gone off the pair of you and got two brand new surveyors to determine the damage or whatever it is arising out of original works. The costs of the two new surveyors are going to be higher, one would have thought, than the original, because the original surveyors know all about the works. The new surveyors have got to read themselves in and are going to want more money. So you certainly can't ask for that extra money because you've chosen to get two new surveyors who have to read themselves in.
That being said, if two parties to a dispute are happy with that setup, would a judge then turn around and say, well, actually, what you've done is wrong? You had a duty of care to the original surveyors, you know, those poor, impartial surveyors. What have you done with them? Where are they gone? I think that a judge would probably be okay with it to say, well, look, was your dispute resolved to your satisfaction with your two new surveyors? And if it, well, I mean, regardless as to whether it was or wasn't, it doesn't seem entirely unreasonable that they did seek two surveyors to settle a new dispute. I can't see it as being entirely unreasonable, but I still believe in a continuity of appointment personally.
Absolutely. To you, Edward, so faced with this conundrum, I said to Nick, I said, well, what do we do about this? He said, well, it's these bespoke letters of appointment. And it's exactly what you said. What is it you're actually being asked? Even if it seems like a straightforward case, does your letter of appointment reflect that? And could we, as you've suggested there, not say that in the event of a further dispute in connection with these works have been notified, and that's what your letter of appointment should say? And it wouldn't be an unfair term or imposition, would it, on an appointing owner to include that in your letter of appointment? And I think that's where we have to really, it's that due diligence I keep going on about. Don't treat every case as though it's exactly the same. We're all guilty of that, aren't we? During a normal working day, you think it's
we love our templates, don't we?
Yes.
Most surveyors love a template.
Yes, I think there's a thing about templates in here, isn't there?
Oh yes, agree.
That's it for part 1 of the podcast. We'll see you in part 2, where we'll discuss the steps surveyors should take to settle a deemed dispute, reasonableness of further inspections, and what can be done to ensure surveyors stay in their lane. We'll see you then.